Dear students, welcome to my YouTube channel, Your Short Questions with Narayan. Titled as Yeh To Aayega Hi. In this video, we are going to discuss about some important and probable questions on hierarchy of courts, jurisdiction of the Supreme Court of India. Supreme Court is a court of record, reference and revisional jurisdiction of high courts, and also some important MCQs on jurisdictions, which will be important for the semester examination of LLB, BA LLB, BB LLB and LLM students. Also important for those who are aspiring to appear in CLAT, ISLET, UGC NET and judiciary exams. So moving to question number 1, explain the hierarchy of courts in India with prowess. Also mention the flow of appeals. Answer: the hierarchy of courts in India is structured in a multi-tiered system to ensure efficient administration of justice. The hierarchical structure ensures that cases can be reviewed at multiple levels, safeguarding justice through an organized and systematic process. It consists of the following levels: Supreme Court of India. It is also known as the apex court or the highest court of the country. Jurisdiction: the Supreme Court is the highest court in India and has both original and appellate jurisdiction. It can hear appeals against decisions of high courts and tribunals. It also handles constitutional matters and cases of public interest. Different jurisdictions of the Supreme Court of India. Original jurisdiction: in disputes between the Union and states or among states. Appellate jurisdiction over civil, criminal and constitutional matters. Advisory jurisdiction for legal advice to the President of India. Writ jurisdiction for enforcement of fundamental rights under Article 32 of the Constitution. High courts. The second court coming under the hierarchy is high courts. Position: highest court in a state or union territory. Jurisdiction: each state has a high court with jurisdiction over civil and criminal cases. High courts handle appeals from subordinate courts and have original jurisdiction in some matters, such as election disputes and matters involving fundamental rights. Powers: the high courts can hear appeals from lower courts, both civil and criminal in nature, can issue writs under Article 226 for the enforcement of fundamental rights and other legal rights. Then comes district court in the number 3 of the hierarchy. Highest court in a district. District courts are the primary courts of original jurisdiction for civil and criminal cases at the district level. Each district typically has a district and session court. Powers are: district judge handles civil cases, sessions judge handles criminal cases. They also hear appeals from subordinate courts. Number 4 in the hierarchy is subordinate courts. Are further divided into two categories based on the nature of the cases they handle. Civil courts: subordinate judges court handles civil cases at the lower level. Munsif court deals with small claims and lower value civil disputes. Criminal courts: the CJM, Chief Judicial Magistrate Court, deals with serious criminal cases. Judicial Magistrate of First Class, that is JMFC, handles less serious criminal cases. Judicial Magistrate of Second Class, it is JMSC, deals with petty offences. In metropolitan areas, we call them Metropolitan Magistrates and Chief Judicial Magistrate. Number 5 is special courts and tribunals. These courts handle specific types of cases such as consumer disputes, income tax issues, or labor disputes. Examples include the National Consumer Disputes Redressal Commission, Income Tax Appellate Tribunal, and National Green Tribunal. Flow of appeals: Decisions of subordinate courts can be appealed to the district court. Decisions of the district court can be appealed to the High Court. Decisions of the High Court can be appealed to the Supreme Court. Discuss the jurisdiction of the Supreme Court of India. The jurisdiction of the Supreme Court of India is divided into four main categories. They are original jurisdiction, appellate jurisdiction, advisory jurisdiction, and writ jurisdiction. Original jurisdiction is given in Article 131 of the Constitution of India. This jurisdiction allows the Supreme Court to hear disputes directly without the case first being heard by a lower court. It primarily includes disputes between the Government of India on one side and one or more states on the other side. Then comes disputes between the Government of India and one or more states on one side and one or more states on the other side. Then comes between two or more states. This jurisdiction is exclusive to the Supreme Court, meaning no other court can decide on these matters. Then comes the writs issued by the court. Appellate jurisdiction given in Article 132 and 136. The Supreme Court is the highest appellate court in India. It has the power to hear appeals against the judgments of lower courts, that is high courts, tribunals in various matters including civil appeals, appeals in civil cases from high courts if a substantial question of law is involved. Criminal appeals, appeals in criminal cases where a high court reverses an acquittal to a conviction or where the high court grants the certificate of appeal. Constitutional matters, appeals in cases that involve interpretation of the Constitution. The Supreme Court may also grant special leave to appeal from any judgment or order of any court or tribunal in the country except military courts, because military cases are dealt by General Court Martial and the courts are established by the military establishments. Third comes the advisory jurisdiction under Article 143. The President of India can seek the advice of the Supreme Court on any question of law or fact of public importance. The court may either give its opinion or refuse to do so. However, this advice is not binding on the President. The first case on which the President of India had sought the advice of the Supreme Court was the Berubari Union case. Then comes the writ jurisdiction. Under Article 32, the Supreme Court has the power to issue writs such as habeas corpus, mandamus, prohibition, quo warranto, and certiorari for the enforcement of fundamental rights. This is a crucial part of the court's role in safeguarding constitutional rights and ensures judicial review. Then comes special jurisdiction, that is public interest litigation. In short, we call it PIL. The Supreme Court can entertain matters of public interest under the concept of public interest litigation. Through this, any person can approach the court even if they are not directly affected by the issue, provided it concerns the public interest. Question number 3. Write a short note on Supreme Court as a court of record. Article 129 of the Constitution of India declares the Supreme Court to be a court of record. The Supreme Court of India is called a court of record for the following reasons. 1. Recording of judgments. All decisions, judgments and proceedings of the Supreme Court are recorded and preserved. These records have evidentiary value, meaning they can be referred to in future cases as legal precedents. Precedential value. The judgments and decisions of the Supreme Court act as precedents for all lower courts in India. These lower courts are bound to follow the legal principles laid down by the Supreme Court, ensuring uniformity in the interpretation and application of law across the country. Contempt of court powers. As a court of record, the Supreme Court has the authority to punish for contempt of itself. This power ensures that the dignity and authority of the court are maintained, and anyone who disobeys or disrespects its orders can be held accountable. Indisputable legal reference. The recorded judgments of the Supreme Court cannot be challenged or questioned in any lower court. They serve as indisputable proof of law and are accepted as authoritative. Write a short note on reference and revisional jurisdiction of high courts. The high courts have both reference and revisional jurisdiction as part of their judicial function. Then let's now discuss about reference jurisdiction. It refers to the power of a lower court or a tribunal to refer a question of law or a point of law, question on the validity of an act, the determination of which is necessary for the disposal of the case in hand, and is of opinion that such act, ordinance, regulation or provision is invalid and inoperative, but that has not been declared invalid or inoperative by the concerned High Court. Relevant provisions under section 113 of the CPC Code of Civil Procedure 1908. If a subordinate court is faced with a question of law that is essential for the case's decision and it believes it cannot resolve the matter, it can refer their issue to the High Court. The purpose of this is to ensure that complex or significant questions of law are decided by the high courts, which have greater authority and experience. Conditions for reference. These conditions are to be met with: the subordinate court must be satisfied that the case involves a question of law. The decision of the High Court on that question is necessary for the case. The court must not have the power to decide the question of law itself. Revisional jurisdiction. What is revisional jurisdiction? It refers to the power of the High Court to examine the correctness, legality, or propriety of any order or decision made by a subordinate court, even if an appeal is not allowed. Relevant provisions under section 115 of the CPC of 1908 and section 397 of the CRPC 1973, the high courts can revise orders passed by the lower courts. The purpose is to ensure that justice is served and that subordinate courts follow the correct legal procedures and principles. Conditions for revision. The subordinate court must have acted without jurisdiction or failed to exercise its jurisdiction properly. The order of the subordinate court may have caused a failure of justice. Revision can only be sought if no appeal lies against the order. The key difference is reference jurisdiction is initiated by a subordinate court when it seeks guidance on a legal issue. Revisional jurisdiction is issued when a party or the High Court itself feels that a subordinate court has acted improperly or outside its legal boundaries. Let's discuss some of the important MCQs before concluding this video. Under which article of the Indian Constitution does the Supreme Court exercise its advisory jurisdiction? It is Article 143. Who can seek the advisory opinion of the Supreme Court of India? It is the President of India can only seek the advisory opinion of the Supreme Court. Is the advisory opinion given by the Supreme Court under Article 143 binding? It is no, it is not binding on the President. The advisory jurisdiction of the Supreme Court is a feature of which form of government? It is a feature of the federal form of government. In which of the following cases did the President of India seek the Supreme Court's advisory jurisdiction? It is the Berubari Union case. For the first time under Article 143, the President of India sought the opinion of the Supreme Court. Which of the following statements is true regarding the advisory jurisdiction of the Supreme Court of India? The true is Supreme Court can refuse don't think that it is bound to answer to the advisory opinion sought by the President. The Supreme Court can refuse to provide an advisory opinion if it wishes. 7. The advisory opinion of the Supreme Court of India may cover which of the following areas? It can cover any legal question referred by the President. Which of the following is not a characteristic of the advisory jurisdiction of the Supreme Court? Here they are not correct. Keep it in mind. It is a consultative nature. This is correct. It can only be sought by the President of India. This is correct. It helps in resolving complex legal questions. That is correct. The opinion is binding on the government. This is not correct. One way Supreme Court is not binding to give the opinion as sought by the President. Similarly, the opinion given by the Supreme Court is also not binding on the government. What does the term revisional jurisdiction of a High Court refer to? The power to revise orders and proceedings of lower courts is referred as the revisional jurisdiction of the High Court. Under which section of this Code of Civil Procedure, that is CPC, can a High Court exercise its revisional jurisdiction? It is section 115 of CPC. The High Court's reference jurisdiction is generally exercised when a lower court refers a case for clarification on a point of law. Answer is C. In reference jurisdiction, a subordinate court may refer a case to the High Court under section 113 of CPC. So the option D is the correct answer. Students, I hope you found this video useful and exciting. If so, then please subscribe to my channel and hit the bell icon to get latest videos updated on subjects. Like it and share it. It's a request from my side. Your comment on the video and what you want me to prepare is vital for upcoming videos. So please do comment. Good luck to you. Do well in your exams. Do well in your life. I wish you all the best. Thank you for watching my video. Thank you.